Hi, Cora Stack here again, Dr. Stack. I want to do another take on this because it's so important to me because of what happened with the original paper that I wrote. So the title of this video, and this is going to be the last one for the moment because of I have other responsibilities. The active omission problem, why the new whistleblower law undermines justice. Now, I've been trying to understand this for a long time. And as somebody says, I think it was Michael Parr, you can't untell the truth. And I'll quote that from Michael Parr, one of the presidential hopefuls, who only spoke in Waterford, and he said, he keeps saying this to me. And I think it applies to this. So copyright 2025, as my original one was, just because I didn't say it was copyrighted. I probably did say it was copyrighted, yeah. So, it was it? Anyway, so my name is, as you know, is Dr. Cora M. Stack, mathematician, academic and researcher in law, governance, public policy, mathematics educationer, and previously pure mathematics and psychology, everything that I'm interested in, all of those, criminology, all of this sort of thing. So today I want to explain a serious flaw in Ireland's new whistleblower legislation, the Protective Disclosures Amendment Act 2022, and why something called an act of omission, something that I was fascinated by. This is what fascinated me, and what the curiosity about this question, huge curiosity drove me to this huge paper, and then giving it to Minister McGrath, and then seeing what he did with it, and he never credited me. Of course he didn't. But see the truth can't be undone. So let's see how we're going to twist it back now. So an act of omission may now escape justice altogether. So I think I previously said that it was an act of omission was replaced by an act of commission. That's incorrect, because I've checked the act. Just looked at the act last night. So I know there's a number of as I say, these EU directives are included, so it's self-contradictory. We'll look at it now. I'll show you how this happened, why it matters constitutionally, and what it means for anyone who tries to speak out against wrongdoing in public life. And this was a very simple question, which took me years to find a copyrighted definition, which I have in my copyrighted paper. But this is a very simple definition, which I think is suitable for the public. So, what is an act of omission? In law, an act of omission simply means a failure to do something you have a duty to do. That's a very simple but very clear definition. For example, failing to act when the law or public duty requires it. As defined by Hill and Hill in their legal dictionary, a failure to perform an act when there is a duty to act may give rise to legal liability, just like a negligent act. Importantly, correcting or judging such an omission usually requires a court order, because only a court can decide whether a legal duty existed and whether it was breached. What changed in the new Act? The 2014 Act was clear. A disclosure was presumed protected unless proven otherwise. Now, there's a very important statement in that Act, the original Act, which I now know was excluded or omitted or deleted from the amended Act. And that is that a disclosure is protected until proven to the contrary in proceedings. I have it off by heart, and that is not in the amended Act. Is that an act of omission by Minister McGrath office? Question mark. So, but in 2022, the law was amended. Now disclosures go first to the Protective Disclosures Commissioner. Now, proven otherwise, proven in proceedings means proven by a court at the circuit. The circuit court, I think, is where that goes to in the first instance. The Commissioner can receive and forward information, but cannot decide whether a public body's failure to act, an omission, actually counts as wrongdoing. Now, I'm not actually sure whether it's the circuit or the High Court, so let's leave it. I think it's the circuit, but it might be the High Court, so I'm not an expert in that, which court it starts at. This means a public body accused of doing nothing can simply say that's not a mission, and the Commissioner cannot rule otherwise. It may be judicial review. Why this is a legal and constitutional problem? So determining whether something is a legal omission involves interpreting duties and rights, and this is key. This is the judicial function, not an administrative one. That's key. So under Article 34 of the Irish Constitution, only the courts may administer justice. This is key as well. When a public body of administrative officer decides, this is key too. Under Article 34 of the Irish Constitution, only the courts may administer justice. So I'm trying to explain all this to the public, in these communication videos. When a public body or administrative officer decides from themselves that a failure to act isn't an omission, including a lawyer, for example, they're exercising judicial power without authority. I mean, that's shocking. That's absolutely shocking. It also breaches Article 40.3 because citizens lose the right to fair procedures and remedy. And it breaches EU law. This is the other act of irrelevant wrongdoing. This is what would you call this? One part breaching the other part. And it breaches the EU law, especially the Whistleblowing Directive 2019/1937 and Article 47 of the EU Charter, which guarantees access to an independent and impartial tribunal. As a mathematician trained in probability theory, I can put it another way. When you remove judicial oversight, the probability of wrongful dismissal of valid disclosures increases exponentially. That's just very colloquial. Probability, as we always know, is measured between 0 and 1. But that's a colloquial language. Each extra administrative step without independent review multiplies the risk that genuine omissions are ignored. That's more factual. Statistically and legal, this makes the system unreliable, very unreliable, I would say. This means that if a government department, local authority or agency fails to act, for example, in handling corruption, abuse and neglect, there are three very important elements of wrongdoing: corruption, abuse and neglect, in my opinion. And, which one of us hasn't been affected by either of those three: corruption, abuse or neglect? A whistleblower can report it, but the report may go nowhere. No one independent has to decide if it was truly an omission. It's through this mechanism of how it was, omitted and deleted, in terms of from judicial oversight, so that it could never be detected, could never be proven. So it's really gaslighting complaints of corruption, abuse, and neglect out of the whole system, which is shocking in the extreme. This is how I see it. The oversight mechanism becomes the loop that protects the institution, not the individual. Absolutely shocking. There are straightforward fixes here. The law should reserve to the courts the power to decide whether failure to act is a legal omission. 2. The Commissioner should be required to refer all omission-based disclosures for judicial review. Transparency provisions should apply. No more secrecy under freedom of information exemptions. These reforms would restore balance, fairness and constitutional integrity. The integrity of whistleblower legislation depends on independent judgment. Only a court can decide what constitutes an act of omission. This was absolutely clear to me when I was doing my research. And then how the courts were summarily dismissed or excluded or deleted from judicial oversight in the amended act just didn't add up. And this is why. Until that distinction is restored, Ireland's legal protection for truth tellers remains incomplete. My name is Dr. Cora M. Stack, and thank you very much for watching.